Advocate Ramsamy have come to expose all Andrea Johnson's lies at Madlanga today as she present fresh evidence against her. Watch till the end and see what she has for us, and please subscribe for more news.
Is the 6th of December. Mm-hmm. Y'all got the dockets on the 9th of December. Mm-hmm. So you wouldn't have had the dockets.
No, I didn't have the dockets. We only received the dockets because on the 6th you sent the letter to Sentumule.
Yes, yeah. That is what I'm saying. So what would you have based, and that's what I'm trying to get to. You based your facts on the Section 27.
Correct.
Did you check to anyone before that, or did you base your facts on anything else for us to have those other names?
It was on the page that you gave me. That's why those names are there.
How do we arrive at some of those other offenses like forgery and uttering and...
Forgery and uttering, we generally put in our 28...
That's how I explained it, but he said, I have abused my power by doing that.
No, it's a standard thing because out of fraud, we get forgery and uttering.
And that's what I said. When you look at that one paragraph where he says the alleged manipulation of procurement processes, that would appear for me and fraud, almost invariably, there is forgery and uttering.
Yeah.
And that if we don't put it in, then we can't deal with it.
And remember with the...
So what they're doing is, do they dissect word for word?
Yeah, that's why I stopped watching.
Yeah. Today I must have been the dumbest lawyer South Africa has seen.
Are you done for the day?
Yeah, I'm actually feeling sick. I got sick last week, remember? Yeah. And I had a panic attack. So for the first time I'm taking meds for it. And after a while I just felt I was soaked. And I realized I wasn't even paying attention.
No, but to answer your question, the names that I obtained or placed in the 2813 was the page with your handwriting and the names of the suspects. And then when I asked about it, you said that you, Dylan consulted with Fadil, and that's how the names came up.
I must talk to Dylan. If we have to have a quick WhatsApp call later, is it okay with you?
No, that's fine. I'm free.
Yeah, because, otherwise I'm very confused because they need to know from me tomorrow. Where did I get these names? And I need to understand where did I get those names. Now, it's fine if you say you got it from me, but I don't know where I got it from.
What you told me is that Dylan obtained it after consultation with Fadil. That is my understanding of it.
Okay. All right. I have to speak to him. I have to speak to him because he must have notes somewhere.
If you look at my emails, ask him to check the emails.
My laptop was stolen, so my laptop was stolen in January last year, so I've lost lots of my stuff.
But ask Dylan to check because he has his emails on his phone. There's an email between him, you, and I about the names as well as about the documents, the ones that were slotted in under Fadil's door. So there was a chain email between us. He should remember.
Okay. I'll talk to him, and then if you don't mind, we'll chat a bit later on. Or else, I go there. I've already now abused my power by not asking where these names came from. I said to them, what? Maybe I had a discussion with you. I just can't remember right now. And which would then be true. We had a discussion.
Yeah.
If you say that there was this paper. But where did this paper come from? Where would those names have come from?
That was what our conversation was. It came from consultation with Dylan and Fadil, and then you had written it down. Yeah.
Okay. All right. I'm going to talk to him, then you and I will check it. But thank you. I'm sorry, but they asked me for the name of every person who's dealt with the matter.
No, it's fine. I don't even know what's happening. I'll be very honest with you. I stopped watching because we are so busy with preparation for blue lights that I just don't have the time to listen.
And I don't watch because it will really, if they call you, you leave the country.
Okay. Oh God. Okay.
It's not what you know.
Okay. No.
I didn't know Section 28. I didn't know Section 27. I know nothing. I'm as dumb as two bricks.
I'm sorry.
Yeah. But it's okay because, you know what? Whether we like it or not, they're going to make our names shut anyway because you can just see, you know, especially when, remember he's a judge. You know, for him to make a comment, oh, well, this is basic law 101. I'm surprised you don't know it with your 30 years experience.
Oh, I don't even know what to say to that.
Exactly. And he's and he makes faces, they laugh with each other while you're still answering. It's so unprofessional.
Yeah, no, I don't want to go there.
Yeah. We'll see what we're all going to do, but it's just going to be a shit show. I'm going to talk to them quickly.
Okay, but ask him to check my emails from, it must have been around the 11th, 12th or 13th of December because I went on leave on the 14th of December. So it would have been the 11th, the 12th or the 13th of December.
But he would have had to speak to Fadil after Fadil gave us the 27th, remember?
Yeah. No, his indication is that he had spoken to him in December, so it was late November.
Yeah, late November.
Yeah.
Yeah, because Fadil's 27 is dated 21 November. So he would have had to speak to him between 21 November and the 5th of December, because on the 6th we signed the authorization with these extra names.
Yeah.
Yeah. Okay. All right, I'm going to talk to him.
Okay, Mama.
All right, thanks,
yeah, no problem.
Okay.
Bye.
All right, bye.
Now you confused me. Good morning, Ms. Selina.
Apologies. As I've previously indicated, Chair, I'm a creature of instruction, so when I'm instructed to move, I move.
Oh, and good morning, Ms. Maya.
Good morning, Chair.
Thank you. And I don't know whether to say advocate. You say you were appointed as an advocate upon joining IDEC, I think you say in your statement. But with regard to admission, I saw no admission other than your admission as an attorney. So it may be a technical issue, but it exercised my mind. So I don't know whether to refer to you as Advocate Ramsamy if you are never admitted as an advocate.
Morning, Chair.
Good morning.
Chair, I'm an admitted attorney.
Yes.
State advocate is the title that is given to a prosecutor upon promotion. So Ms. Ramsamy or Drew is fine.
And you are perfectly fine with it?
Yes.
All right. Good morning, Ms. Ramsamy. Thank you very much. Let me just, before we start, say something. We received the statement, I think, in the evening yesterday, I think.
Yes, Chair. Perhaps before you make any remarks regarding the statement, may I address the commissioners?
Yes.
Because I have got a request to make.
Yes.
As the commissioners are well aware, as we were leading the evidence of Advocate Johnson, some of my colleagues were attending to other matters, including this particular witness.
Yes.
Now, the administration hasn't quite caught up, I think, with us.
Yes.
So even the witness doesn't have a statement, so we can't start. I was going to ask for a stand down to allow copies to be made and at least avail to the witness to enable the proceedings to start.
I thought the one we got was the electronic version. Aren't we able to start perhaps using that electronic version so that we try to save time?
It's clarified for me, Chair.
I'm actually being shown a hard copy in front of me.
Yes. Though the witness may have an electronic version of her own statement,
Yes.
she has got significant annexures, and it's the production of those files that seems to have been delayed.
Yes.
Advocate Sigals-Ngube would, if she had her way, her preference would be to start
Yes.
with the annexures immediately available for the witness, but we are not currently in that position. I'm not in a position to indicate how long a stand down would be required.
All right, then we'll stand down. But let me. That's your preference. Good morning, Ms. Sigals. Is that your preference?
Yes, Chair, that is the preference, and
All right.
witness's preference as well.
Oh, all right, all right. Let me raise the point or the issue I wanted to raise.
Yeah.
Having gone through the electronic version of the statement, which, as I say, we received in the evening yesterday, I noticed, and this must be true of my colleagues as well, that the statement implicates Advocate Johnson quite seriously. What I wanted to raise, I do have thoughts of my own as to why what I'm going to raise did not happen. My mind is focusing, for example, on the fact that what Advocate Johnson is implicated on was not put to her. I can imagine why not, but I would like you to please comment on that, Ms. Sigals, and Ms. Sigals Ngube, and perhaps also address us on how, in practical terms, this is going to be addressed so as to treat Advocate Johnson fairly.
Thank you, Chair. Chair, the position is that on the 22nd of July, when Advocate Johnson gave evidence regarding certain events that occurred in the Mokwele investigation, she mentioned the name of Mrs. Ramsamy. And during that evidence, I received personally, because I was assisting Advocate Selo, I received a message from a DPCI officer who had indicated to me that Ms. Ramsamy had made certain disclosures to him regarding these matters and had wanted to consult on the matters. That is why I excused myself from those proceedings and discussed it with the NPA, and we arranged a consultation with Ms. Ramsamy for the 22nd of July while Advocate Johnson was giving her evidence. So we first became aware of these allegations against her during her evidence, and the witness was very clear that she had wanted to give evidence in public. She was aware of the allegations that she was making, that they were serious, but had not wanted them to be put to Advocate Johnson until she had been given an opportunity to give her full version, because her intention was in any event to only make this disclosure under protected disclosure protection after Advocate Johnson gave her evidence. But given that Advocate Johnson had implicated her in these proceedings, she thought that the correct process to follow would be to come to us with that evidence. So we did not have this information prior to Advocate Johnson giving her evidence. It only became known to us during her evidence. The intention is to serve a Rule 3 notice on Advocate Johnson to address these allegations, Chair. And that will be done during the course of today and tomorrow, depending on whether there are further matters that emanate from her evidence. As Chair would notice from her statement, she wants to give evidence in 2 parts, and she's only submitted 1 statement thus far. There will be another statement which further implicates Advocate Johnson. So it is either that we'll serve the notice today in respect of this first statement, or we will wait until she concludes her evidence on both statements. Second statement not yet provided and concluded, and then we will furnish a full Rule 3 notice on Advocate Johnson.
Did not sit well with me. Page 3.
Yes, page 3, paragraph 6.
You'll see after you deal with the 3 points, you then say, I refer in particular to the application for authorization. Do you have that?
Yes.
You can read from there. I refer in particular to the application for authorization of a Section 2813 investigation that I prepared on the 5th of December 2024.
I will explain why this did not sit well with me. However, the commissioners must bear in mind that at this point, Advocate Johnson had stated they had made a decision that the matter was to proceed in terms of Section 2813, and that I was to draft the authorization and email it to her on the same day that the referral was handed to me, because she wanted to approve it by Friday, the 6th of December 2024. I deal with this fully later in the statement.
Continue.
On or about the 30th of June 2025, after the Mokwela arrest and the first appearance, I contacted a DPCI officer. I must state I trust this DPCI officer, which is why I contacted him, to inform him that there's a problem at IDAC and that I need to see him and explain and show him the documentation that I had in my possession. I asked if I could do protected disclosure. We agreed to meet on the 2nd of July 2025, where I showed him a prosecutorial memo prepared by me and another prosecutor regarding the matter of General Masiamula and Lieutenant General Kumalo, which I deal with later. He said that he would speak to a colonel at the DPCI and get back to me as to how we were to proceed. The reason that I contacted DPCI is because I had previously, in late April 2025, informed Advocate Santos Manilo, the DDPP that I report to, of the discord amongst the team being that of the crime intelligence investigation, and that the investigation procedures were being flouted and that the investigation was sloppy. He replied that he had his own problems. In August 2025, I started collating documents regarding what I considered to be unlawful instructions from Advocate Johnson and Mr. Perumal regarding project diversion. May I proceed?
Ms. Ramsamy, sorry. When Advocate Manilal says he has his own problems, was it about the same issue, the crime intelligence investigation, or?
He had not, although he was on paper as the deputy director, he had not been briefed on the matter, which I do discuss later on in the statement.
The question I'm asking is, when he said he has his own problems, did you understand him to mean about the same subject, the same investigation, or he had his own problems within IDEC? I'm just trying to understand what it is he was.
I understood it to mean that he was not interested in my problems and this project.
I see. Yes, thank you. That answers me. Thank you.
Okay, continue.
On the 8th of August 2025, Advocate Peter Surunya, a deputy director of public prosecution, came on board the Mokwela and Lushaba cases. He started sending emails and memoranda that accorded with my concerns on how the Mokwela matter was being conducted. Advocate Joyce Swayo and I also approached Advocate Surunya with our concerns. He can confirm this to the Commission. When Advocate Surunya requested to be removed from the Mokwela and Lushaba cases, I was removed from the Mokwela case, and although I was apparently kept on the Lushaba case, I was excluded from the case from September 2025. I also approached another deputy director and showed him all the documentation that were concerning. He stated, these things will never come to light. In November 2025, after Advocate Johnson testified at the Advocate Committee, I contacted the same officer at the DPCI. I informed him that Advocate Johnson had lied to the Advocate Committee and that I had proof of this. Once the new NDPP, Advocate Matibi, was appointed, I met with the DPCI officer. This would have been around March 2026.
Can I just interject to ask you why it's significant that you mention once the new NDPP was appointed? Did you meet with the DPCI officer?
Because I knew that if I had reported or we had taken these concerns to this then sitting NDPP, nothing would have been done. Advocate Johnson, there would be no repercussions, there would be no corrective measures.
By that you mean Advocate Shamila Batoy?
Correct.
Why would you have formed that opinion?
I was aware of the matter that was discussed with the commission about the sharing of documents, but that was corridor talk, so I wasn't confirmed. But if I may put it frankly, from a prosecutor's point of view that's in the office every day, Advocate Johnson was the blue-eyed girl of Advocate Batoy. She could do no wrong. If needs be, or if the commission so sees fit, if you look at any grievance that was sent about IDAC from the staff members, it was squashed to an extent where people started just resigning. People were applying for posts. I'm an SA. I've been applying for SA posts just to get out of that unit.
And you referred to the sharing of documents